Good morning and welcome to the latest edition of Petexia's IP Matters webinar series. We're very excited to be here today for PTAB's Success by the Numbers with John Callahan. John will be presenting on key aspects of successful practice before the USPTO's Patent Trial and Appeal Board, or PTAB. His presentation will look at what the statistics from the first 3 years of inter partes review proceedings reveal and how those statistics should guide practice before the PTAB. John is a partner with the Washington, D.C. law firm Sughrue Mion, PLLC. His practice focuses on proceedings before the PTAB, where he has appeared numerous times. He lectures on IP topics frequently and will be speaking next in New York City on February 23rd through 25th at a patent conference on life sciences and medical devices. So we're very lucky to have John here with us today, and without further ado, I will switch over to him and let him get started. John, over to you.
Okay, great. Well, thank you, Zoe. I appreciate that introduction very much. I also want to say thank you to you and your team at Petexia for putting this together. I think it's been great so far for me, and hopefully it'll be a great experience for everybody listening and watching. I also just want to say thank you to a few people here at Sughrue that helped me with this presentation. A couple of my colleagues, Andrew Ritter and Travis Rebar, and also my assistant, Elaine. Now, without further ado, what I'd like to do is jump right into the presentation. The goal of this webinar is twofold. First, I want to talk about statistics to date. What do they suggest? And two, also discuss some of the underlying trends in the field of IPRs that are the reasons for the statistics. I'm going to defer to Zoe, but please send in your questions and comments. And I believe we're going to be answering them at the end. But again, I'll defer to Zoe, but I'll just note that I was the last of 6 children growing up, and I have 3 children myself. So I'm used to being interrupted. Any way that Zoe wants to do it is fine with me. Okay, looking at slide 3. This is essentially an outline or a roadmap for what I'm going to discuss today. The topics for today are going to be the statistics. What do they reveal? After 3 years, we have a pretty good feel for how these proceedings are going to play out. And I think that the statistics are very revealing or interesting. Then I'd like to, given those statistics, I'd like to discuss what I feel is driving those statistics from both the petitioner's perspective and also the patent owner's perspective, and what each of the petitioner and the patent owner can do to best prepare themselves for a successful outcome in the case. So from the petitioner's perspective, we're going to touch on the ideas of what to consider when preparing the petition, issues relating to the so-called real party in interest, the use of experts, and the notice requirements. From the patent owner's perspective, I'm going to touch on the idea of the preliminary response, the amendments that can be made, and also the idea of settlement. Now, first slide relating to statistics is the pie chart on slide 4. And this is data that we retrieved from the Patent Office for fiscal year 2015, but only through August 31st of 2015. We included the information on the upper right side so that people can take a look at the Patent Office website to look at these statistics themselves. But it's easy to see that the great majority of the IPRs are filed in the electrical, computer, and mechanical fields, and that's about 86%. Only about 14% are in the chemical, biotech, and the pharma sides, and only about 5% in the chemical area. So what this reveals is the chemical attorneys are kind of feeling left out. But the next slide is, I think, very informative. This is also taken from the Patent Office website. And it's an interesting slide because it shows a lot of good information. First, the snapshot here is of the outcomes for all IPR petitions filed to date that have reached a final disposition. So that's the 1,901 IPRs, and that's the total finished IPRs as of August 31st of this year. And you can see that there were 1,012 IPRs where the petition was denied, or the IPR was settled, or the IPR was dismissed. That's the gray hexagon on the left side. But also, of the 1,901, 889 IPRs had trials instituted. And of that, 407 were terminated during trial. Again, either through settlement, dismissal, or an adverse judgment. But what's important to see, I feel, is that 482 of the 889 went to trial. In other words, the trial was completed. It reached a final written decision. And of those 482, 327 resulted in all of the instituted claims, meaning the claims subject to decision in the IPR, were held unpatentable. In addition to that, in 82 trials, some of the claims were held unpatentable. In only 73 of the trials were no claims found to be unpatentable, or in other words, the patent owner had a completely successful outcome. So what are the takeaways from here? Really, in my opinion, only a small number of IPRs are getting to a completed proceeding. And of those that get to that point, the patent owner should be pretty nervous about what the outcome is going to be. As we'll talk about towards the end of the presentation, the net effect here is that if you're a patent owner and you're going through this proceeding, is you seriously want to consider settling it. Now, our next slide includes some additional statistics. Essentially, this is the slide with the cylinder graphics on it. This is another way to look at the data that was presented on the previous slide. And I feel that it's an interesting approach because it's a finer review of the information that was presented in that previous slide. This slide breaks down the information to the level of the individual claims subject to challenge in the IPR proceedings. Now, the left cylinder, the one that's all red, represents the total number of claims that could have been challenged in the 1,901 total petitions on the previous slide. It's a fairly large number. It's almost 60,000 claims. Of those, 29,137, roughly about half, were challenged in an IPR. Breaking it down further, of those, an IPR was instituted for 12,153. So that represents approximately 42% of the claims challenged. Now, when you get to the final cylinder on the right, you see that of those instituted claims, 5,114 claims were found unpatentable, again, for an amount of about 42%. So the takeaway from these statistics, I feel, is that roughly 40 to 45% of the claims that are subject to an IPR are going to be defeated under the current atmosphere and conditions. And I feel that that's kind of very interesting statistic to be looking at when you're a patent owner, and very appealing statistic to look at if you are a potential petitioner. But we also wanted to look at this from a slightly different angle. The statistics that we've looked at so far have been statistics from the Patent Office. We also were trying to determine what happens after the PTAB issues their final decision, and what are the statistics there. It's a little hard to get our hands on that, but what I'd like to do is look at this graph on slide 7, and this shows statistics relating to appeals from the PTAB to the Federal Circuit. And we pulled this chart from the Federal Circuit's website. And it shows the origin of appeals to that court. And what I'd like to direct your attention to is the black line in the graph that represents appeals from the U.S. Patent and Trademark Office. And that begins on the lower left side. It's the one just above the bottom line relating the orange line. But it's clear that the number of appeals from the USPTO from fiscal year 2006 to the middle of fiscal year 2013 bounced around in a band between about 50 to about 150. But then there was a very significant change. It skyrocketed in the next 2 years to over 400 appeals from the Patent Office to the Federal Circuit. So the beginning of that steep increase corresponds to when we started the IPR proceedings. And we don't have hard statistics, but on pretty good information, it's being said in the industry that between about 1/3 to 1/2 of those appeals from the PTAB to the Federal Circuit are being decided on what's called a per curiam basis, which is also under Rule 36 of the Federal Circuit rules. And what that means, if you're familiar with it, is that the Federal Circuit is simply affirming the lower court's decision, in this case the PTAB, without any discussion. So it's called a Rule 36 affirmance. It's a one-page form where the Federal Circuit says we basically agree with the court below and affirm its decision. So what does that mean? In my view, it means that the PTAB's decision is likely going to be the last word on the patentability of the claims at issue. So I feel that looking at the statistics from the Patent Office, it's fairly grim for patent owners when you get to a final decision. And then looking at the statistics from the perspective of the Federal Circuit, there's not likely going to be any relief. It's pretty clear based on what we're hearing that the Federal Circuit, for the most part, doesn't want to disturb the decisions that are coming out of the PTAB on the IPRs. So that, as I said, that completes the slides relating to the statistics. I feel that they're very informative. Now what I'd like to do is address what we feel is sort of driving those statistics. But before diving into those additional slides, I'd like to, if you'll indulge me for a minute, provide my comments, a comment or two, on how to think about these IPR proceedings. Because I think it does have an impact on what you do as a petitioner and what you do as a patent owner. First and foremost, in proceedings before the PTAB, it's important to understand who your audience is and what motivates them. The PTAB is an Article 1, so-called Article 1 court, meaning it's part of the executive branch. The U.S. Patent and Trademark Office decides issues of patentability, not issues of validity. And I use those two words very deliberately. And if you practice before the PTAB, you'll know that there's one judge where if you say in a hearing the word validity, that person will stop you and say you mean patentability. So they really do take this seriously. But what this means is that unlike district court, at the PTAB, in an IPR, there is no presumption of validity of the patent. The claims are given their broadest reasonable interpretation. The burden of proof is simply preponderance of the evidence, not a cleansing standard as in district court patent litigation. And also, the standard for instituting an IPR is simply that there is a reasonable likelihood of success on at least one claim. So, given that sort of background, what I'd like to address in the next slides is what you want to think about as either a petitioner or a patent owner in order to be successful. Okay, first we're going to look at this from the idea of a petitioner's perspective. Points to consider. So slides 9 and 10 relate to points that the petitioner should consider when preparing and filing the petition in order to be successful. Slide 9. There are very specific rules covering every aspect of how the petition should be prepared. And what I'm talking about are format issues, largely, but primarily page limits, but also the font size of type, and even the idea of the use of footnotes. So my point here is that there are very, very specific rules that have a history in the Patent Office proceedings. For example, there's even a rule on the size of the margins in papers that are submitted at the Patent Office. So you really need to work with attorneys who are very, very familiar with the rules and do not make missteps that are avoidable. And it is the case that the Patent Office will kick out a petition or a paper filed in an IPR if it doesn't comply with these rules. You also want to think about limiting the grounds of unpatentability that you assert. Generally, the PTAB is not receptive to numerous grounds of unpatentability and the citation of many, many references. Citing tens of references doesn't make the case more persuasive. In fact, might get the petition denied. Now, moving to slide 10. It's clear that in a petition for an IPR, the petitioner must put their best foot forward and trim, or better yet, eliminate the weaker arguments. A good example of that was the Garmin case. The petition was limited to 2 separate combinations of prior art, and it was granted. Another important point is the claim charts. Claim charts are an essential part of the petition, but it's important not to put argument in the claim chart. The claim chart should simply be a correlation on an element-by-element basis of each claim limitation with the most relevant section or disclosure in the reference. I'm a patent attorney, and I do a lot of client counseling, writing letters, opinion letters for clients. We often include claim charts, and simply it'll be the claim limitation and then a quotation of the relevant section of the prior art and a citation to a column and line number. That's what the Patent Office is looking for. Okay, moving on to slide 11. This is a pretty interesting area now for the petitioner. This is a so-called real party in interest. The petition for IPR must identify all real parties in interest. The reason is because the estoppel provision of the IPR attaches to the real party in interest. So you can appreciate that there's opportunity for mischief here by the lawyers. But the USPTO wants the estoppel to attach to the appropriate party. And the estoppel will prevent that party from raising the same prior art against the patent in a subsequent Patent Office proceeding and also litigation. And this comes up more often than one might think. A couple of contexts that I've seen it is in the context of a petition filed by a foundation and also petitions filed by joint defense agreements. So a foundation, as you can appreciate, is sometimes funded by other entities. It could be an individual, it could be corporations. So a IPR filed by a foundation might raise red flags as to the real party in interest. Also, a lot of IPRs are filed in connection with litigation. Litigation sometimes involves a joint defense agreement among various parties. Now, one of those parties might file an IPR, but another party might be actually funding the joint defense agreement. So there can be issues about the real party in interest in that context. And what we are seeing now is that if the real party in interest identified by the petitioner in the petition for the IPR seems wrong or incomplete, the patent owner might raise that issue in a preliminary response prior to institution of the IPR to flag that issue and also request briefing on and discovery on the issue of who actually is the real party in interest in the event that the petition is instituted. Just quickly, looking at the slide, we've included the definition so far in the cases from the PTAB relating to real party in interest. It focuses on the existence of a financially controlling interest in the petitioner, but it also looks at the relationship, the non-party's relationship with the petitioner, the non-party's relationship to the petition itself, including the nature and degree of involvement in the filing, and the nature of the entity filing the petition. And that's kind of what I raised a minute ago. foundations, joint defense agreements. Okay, next, moving on to the idea of expert testimony. And we've fleshed this out on our slides 12 and 13. But expert testimony is very critical, quite frankly, for both sides, the petitioner and also the patent owner. But this is a very important point for the petitioner. Experts play a crucial role in IPRs. They're the backbone of the petitioner's case, as well as the patent owners. And the key aspects include their declaration must be clear and complete in presenting the testimony. And it has to hit all of the marks that the PTAB is looking for. It should avoid conclusory statements. It should explain why the claimed invention would have been prima facie obvious to a person having ordinary skill in the art at the relevant time frame. And that's important. It shouldn't be obvious to the expert. It has to be obvious to a person of ordinary skill in the art. And there is a particular time frame. It's at the time of the patent owner's invention, which is always going to be their filing date. And it also should provide backup evidence, sort of corroboration to the expert's testimony, or else then it's just the expert's bare testimony alone. But what we're talking about is the idea of literature, other patents, other things that can corroborate and substantiate the expert's testimony. Looking at slide 13, it goes without saying that if the proposed rejection is based upon a modification of a reference, the expert must explain, again, from the perspective of a person having ordinary skill in the art, the rationale or motivation for that modification. And lastly, the expert's declaration can't stand by itself, in the sense that the expert's testimony should be fully argued in the petition and in the motions paper. The petitioner can't simply refer to the portions of the expert's testimony. You can't do that. You sometimes see that as sort of a page-saving technique. The board won't accept it. Now, the last issue from the petitioner's perspective is the idea of notification. This kind of goes back to a point I mentioned earlier, which is making sure that you dot all your I's and cross all your T's in the petition itself and in all your papers in an IPR. This one last slide relates to the idea of the petitioners must disclose all litigation and all other PTO proceedings relating to the patent. And the failure to do this, believe it or not, could get the IPR kicked out. All right. Next, what I'd like to do is I'd like to transition to the idea of thinking about things to do or not to do from the patent owner's perspective. Again, with the idea that these are things that are driving those statistics that we talked about earlier. So looking at slide 16, what I'm going to talk about from the patent owner's perspective is three things: preliminary responses, amendments, and the idea of settlements. So with regard to a preliminary response, there's kind of a history here in the sense that in other patent office proceedings, we would typically counsel our clients, and what I mean by this is re-examinations. We would typically counsel our clients to not file a preliminary response because it would give the requester of a re-examination an opportunity to put another paper in. So the background and history here is that in the ex parte re-examination proceedings in the past, and continuing in the future, that is still a proceeding you can use. When a third party files a request for ex parte re-examination, if the patent owner has an opportunity to put in a paper before the patent office grants or denies the request. But if the patent owner puts in a paper, then the requester has an opportunity to reply to that. If the patent owner does not put in a paper, then the patent office will grant or deny the request. If it's granted, the re-examination proceeds in what's called ex parte fashion, which is the patent owner corresponds alone with the patent office. It's a public proceeding, so the requester can watch it. But the patent owner can go in and have an interview, can file amendments as a matter of right, can add claims amend claims, delete claims. It's a whole new ballgame in the IPRs in the sense that in view of the statistics we talked about earlier, the patent owner wants to do everything they can to either avoid an IPR being instituted or shape it going forward if it is instituted. So we typically counsel clients now in the IPR situation to file a preliminary response so they can do just that. They can propose a claim construction. They can also argue that maybe, for example, the real party in interest is not accurate or incomplete. Okay, but this is kind of a very important part. Now on slide 17 of the presentation. I feel that the single most important factor driving the statistics, in particular, the number of claims being held to be unpatentable in IPRs, is the virtual inability of the patent owners to make amendments to their claims. And this slide shows the current standard. Amendments during an IPR to the patent claims are allowed, but the patent owner has the burden to establish by a preponderance of the evidence that the amended claims are patentable over the known prior art. And I'll talk about what that means in a minute. But essentially, that's going to mean not only the prior art of record in the IPR, but all other prior art that the patent owner is aware of. So let me move on and discuss some of this in a little bit of detail. Slide 18. Slides 18, 19, and 20 relate to the requirements for making an amendment. And I won't go through these in great detail, but I think you can take a look at these, and our goal was to provide you with a reference material for future consultation on some of the specifics here. So I'll discuss these at a fairly high level, but this slide calls out the details. Essentially, the PTAB makes it very hard to get claim amendments. They must be done early in response to the institution of the proceeding. The patent owner must ask the PTAB judges. And what that means is that they actually have to call the PTAB, schedule a telephone conference, include opposing counsel, explain what amendments they want to make, why they want to make it, make a proffering of evidence that would support it, certainly enough information for the judge to either grant or authorize the motion or deny it. And you cannot add any claims. This is simply a one-for-one exercise. If you want to amend a claim, you just propose a substituted claim for that claim. Unlike a re-examination that I mentioned a few minutes ago, where you can amend the claims as a matter of right, in an IPR, you cannot do that. There is some ability to add some claims, but the case law from the PTAB says that it's virtually impossible, essentially. So the theme here is that an IPR is not an examination or a re-examination. It's a trial as to the patentability of the claims at issue, essentially an up or down decision on the claims that are subject to the IPR. Just quickly, looking at slide 19, these are some more points on successfully amending claims at the PTAB. To be successful, you need to make the decision to grant or deny that motion as easy as possible for the PTAB judges. So first, you can't broaden the claims. Even if you narrow one limitation of a claim, you cannot delete another limitation or broaden it. So any broadening of any limitation is not allowed. In addition to that, as I said, you need to make this exercise as easy as possible for the PTAB judges to grant it. And in order to do that, you have to clearly describe where there is support for the amended claim in the specification. The standard is the same. Under the case law for written description support, you have to show that the inventors had possession of what you're now attempting to claim. So that part of it hasn't changed. But you have to very persuasively make your case that this is part of the original invention by the inventors. And you can't pull together what I'll call disparate parts of the specification and say, voila, we have support. Next, just moving on to the last slide about amendments. Here's some more details relating to successfully amending the claims. You have to identify the new feature that you're claiming versus how it was claimed previously. You have to provide technical facts and reasoning in support of the patentability of that new amended claim feature. The Patent Office, PTAB, likes the patent owner to use a table with the new claims and then clearly explain the proposed claim construction for the amended subject matter. Now, as I alluded to before, it's also required that the patent owner must distinguish all known prior art. And that means exactly what I said. It's not only the prior art of record in the IPR, it's theoretically all the prior art that the patent owner is aware of over their complete existence. So it's quite a high standard. No prior art search is required under the rules, but a prior art search and an expert declaration testifying that the prior art found in the search is the closest art can be very persuasive in demonstrating patentability. Okay, last slide is the idea of settlement from the perspective of the patent owner. The IPR proceedings are quite unique in this aspect. Nothing like it at the Patent Office except in the old interference proceeding. And even in that proceeding, you could settle a case, but the Patent Office still needed to know who's the first to invent. This is a situation now where the IPRs can be filed by the petitioner in order to perhaps gain leverage in a business negotiation with the idea that the parties might essentially settle it or might eventually settle it. So you see IPRs being prepared, being perhaps shown to the other side in a business negotiation, saying, you know, this is what we want, and we have our IPR prepared, and we're prepared to file it if we don't negotiate this. But an important aspect of settlements in an IPR is that the settlement agreement must be made of record at the Patent Office. So you can see where this is going. The Patent Office doesn't want to be party to, you know, collusion between companies, an agreement to settle an IPR, perhaps in exchange for something else. So the agreement has to be filed at the Patent Office. The parties can file it under seal, and they can request that it be maintained separate, under seal, and not shown to anyone except for, not shown to a third party except for where there is good cause. Now, that's the idea of the webinar we wanted to present today. But I wanted to finish with settlement because I think that brings us back to where I started, the idea of the statistics. The statistics are not very favorable to the patent owners at this point. If you get to the final proceeding, final decision, there is at least a 40, perhaps a 45% chance that some of the claims are going to be lost. So I would encourage parties to, you know, negotiate a settlement if possible. And if that's not possible, then to look at some of the points that we've discussed today, to try to best position yourself to be able to have a successful outcome in the IPR. With that, I thank everybody for listening and attending today, and I'll turn it back over to Zoe.
Thank you so much, John. We really appreciate it. That was very informative, and I definitely learned a lot. We did get 3 questions that came in during the course of your presentation that I will read out for you, and maybe we can get your perspective on. The first question came in, said, you mentioned that 40 to 45% of claims subject to IPR are likely to be defeated. Do you think that is an indication that there was a low initial patent quality in a number of these patents, or that the PTAB is overly aggressive in their decisions?
Great question. And there are some theories out there just on that topic. I do feel that perhaps the first wave of IPRs were focused on patents that maybe were a little bit weaker than some others. People have said that. I think I do agree to that to some extent. So it is possible that these statistics may change over time. Another, interesting aspect of that too is the Patent Office was originally expecting about 400 IPRs per year, and what's being filed now is about 1,700. And they budgeted a certain amount of resources to be able to handle that. And perhaps it's possible that some of the denials of the institution can be a reflection of that situation. I don't mean to be derogatory, but what I do mean to say is that, like the question raised, there could be some other, forces at work here that could be potentially skewing the statistics one way or the other. But I do feel that this is 3 years of data, so it's a pretty good snapshot. I don't think we could do this prior to 3 years. I think after 5 years, maybe that statistic that was the subject of the question will even out a little bit. I don't know. But great question.
Perfect. So the next question that we have is, you discussed limiting the grounds for unpatentability for a single petition. Have you found that beyond not using too many grounds, are certain approaches viewed more favorably?
Okay, so beyond not using too many grounds. I mean, a guidepost here is clearly you want to put yourself in the shoes of the judges at the PTAB. And the more that you can do to ensure that you are complying with every aspect of the rule and clearly and concisely setting out the bases for the grounds of rejection, I feel more likely the petition is going to be granted, because it's human nature that we only have a limited amount of time to allocate resources to what we're doing. And the easier it is for the judges to grasp what the issue is, the easier it is for the judges to understand the expert's testimony and to see, as I said, the perspective of why or why not this is patentable from a perspective of a person of ordinary skill in the art at the relevant time, the more likely you're going to be successful. So my advice, my overarching advice would be to keep it simple, keep it clear, keep it concise and crisp, and make it as easy as possible for the judges to grant the relief that you're asking for.
Great. And one last question. Do you anticipate any changes to the PTAB standards for amendments going forward?
There was a recent small change. The prior language about the art that you're aware of was a little bit more draconian. Frankly speaking, I think that given the fact that these proceedings are not intended to be an examination, I don't see any relief coming anytime soon. If you look at the idle-free decision, the judges were very clear that if a patent owner wants to amend their claims, there are other Patent Office proceedings available to do that. And they mentioned specifically the idea of re-examination and also reissue. Re-examination we talked about for a few minutes. Reissue is a little bit different. Not very favored by patent owners, because essentially you have to admit that there's a mistake in the patent and in some circumstances surrender the patent. But it's clear, I think, from the idle-free decision that Patent Office, PTAB, does not want to entertain amendments to the claims, and they feel like if the patent owner wants to amend the claim, they should file a re-examination proceeding. Now, just as a quick footnote for that, that doesn't mean that you have a free hand in a re-exam to amend your claims. because you do have to inform the PTAB that the re-exam's been filed, and likely the PTAB will consolidate the two proceedings, the IPR and the re-exam, and maybe stay the re-exam pending the outcome of the IPR. But at least you've told the PTAB, hey, I want to make some amendments to these claims. And you do everything you can to try to get in a position as a patent owner to be able to make those amendments. So I don't see any relief coming anytime soon. I think more likely you're going to have to try to use a re-exam and then try to get that before the PTAB and say, this is the relief we want. It should be taken into consideration in the IPR decision.
Perfect. That's it for the questions that came in for us today. I wanted to really thank you, John. I think it was a great presentation, very, very informative, and definitely the statistics were really, really illustrative, I think, of a number of points that we've been hearing about in the media, and gave you kind of the reality of the situation there. So thank you very much for that.
Well, thank you. Thank you for the opportunity, and thank you to everyone for listening.
And just a quick reminder, we do have another webinar coming up in January. This was our last one for 2015, but coming back January 14th, 2016, we'll have Deborah Sterling from Stern Kessler discussing lessons from practicing at the PTAB and a continuation of this series. So thank you all for listening today, and we're looking forward to seeing you next time.